of roll number 1 and 2.
Vacation stay.
Lordships.
Yes.
Lord, we have filed our
Millards, may I just
response,
mention
Millards.
one fact,
We have
Millards?
filed our
Yes,
counter
please.
affidavit,
That
and we have
passed an
also
order
filed
on
an
the
application
14th
for
of this
vacating
month
the stay order.
saying
Millards.
allow
Right.
them
We'll be here
to
this petition
apply
finally.
online.
Instead
Not
of
yet.
purchase order in
But we are
the
on the
vacation.
24th
Lordships.
today, 23rd
Yes.
today. Millards, may I just 24th today,
one fact?
and they have not allowed
Yes,
us.
please.
Lordships had passed an order on the 14th of
Sorry?
this month. Hold on. Let
Saying
me
allow
state the fact. Them to,
Millards, when the
apply
portal was
online.
closed on the
Yes.
20th,
We are on the 20th.
then they filed an application in this court
today,
saying we can't do it.
24th today, and they have not
So
allowed.
this is pure contempt.
Let's have
They should
Lord.
first
Sorry?
allow us.
Hold on. Let me
apply
state
through
the
the portal.
fact.
They can
When
then
the
argue the
portal
matter, but
was
they can't
closed on the
disregard your
21st.
lordship's orders like this. Then they
Yes.
filed an application in this court saying we can't do it.
Yes, please.
This is pure contempt.
It's not correct.
They should
Think
first
that we
allow
are
us
disregarding
to
the order.
apply through the
Let's, we have
portal.
placed on record.
They can then argue the matter, but they can't disregard your
feasibilities
lordship's orders
in
like
the
this.
available software application or module to incorporate by changes
Yes.
this category. That is the difficulty, Millards. Second difficulty is, Millards, with regard to the aspect that this category, your lordships have said that benefit should be given. Whether the benefit should be given at par with the age relaxation of SC, ST or OBC. That also has to be clarified and taken into account. My technical team has advised me that for this purpose, in order to keep them as a separate class segregated for the purpose of adjudication and consequential aspects, a new software application will have to be developed. And after that development, it has to be tried and then it has to be audited from the technical concerns by the team of the experts. Then only it would be feasible for the purpose of opening up a window for these persons to make an application.
Yes.
As of now, it is technically not feasible and totally counterproductive. That is the aspect which I have prayed your lordships to consider in the additional affidavit. That the current application of the current category of candidates is going to be finalized by 28th. Because one week window is provided for the purpose of carrying out corrections in the applications already. After that, cutoff date, if that after that window is completely closed, then we will be in a position to work on this window and take the necessary steps for the purpose of compliance.
Yes.
This
Have you placed something on record?
Yes, I have filed the additional affidavit on record,
Sure.
in which this position has been explained in detail. Para onwards,
Today 9.
Para 10 onwards. It is document number 63 of 25, registered by your lordship's gracious order today.
Yes, not the
नहीं है ये अपलोड हुआ नहीं अभी
आज ही पेश की
only today you have also
Yes, I'm told that it has been registered and uploaded on your lordship's file. Upload नहीं हुआ है.
अच्छा anyway we'll see to it. Yes, please argue the matter. We'll see thereafter because let this additional affidavit be uploaded.
Very well, Millards. I'll argue the matter straight away, Millards.
Yes,
All
better
this-
you start the matter and we hear the argument so that this issue can be decided as early as possible.
Yes, Millards.
Yes, please.
Page.
Millards, may I make my submission?
Yes, please.
No, Millards. Very simple, Millards. In 5 minutes, I'll make my submission. Millards, your lordship is aware of the fact that there was a 103rd constitutional amendment which allowed for 10% reservation for EWS. That is the economically weaker sections. That was the 103rd constitutional amendment, which was upheld by the Supreme Court in Janhit Millards Kalyan matter, Abhiyan matter. Your lordship is aware of the matter. Millards, thereafter, through a 105th constitutional amendment, Millards, the Constitution provided that state OBCs can also be identified apart from the central list of OBCs. Right? That was in the Maharashtra matter. That also was upheld. So we have a central OBC list and a state OBC list. Correct, Millards? Now, the problem is the following. As far as the central list is concerned, Millards, OBCs, according to the government, are not part of EWS. EWS is a separate category. They are not part of EWS. So a question arose whether EWS is entitled, whether OBCs in the central list are entitled to the benefit of age relaxation and the benefit of 3 additional chances. That question arose, Malads, and your lordships will find that at page, the reply, there was an FAQ, and you will find that at page 89 of the paper book.
This was done while the arguments in Janhit Abhiyan.
This was done while the arguments in Janhit Abhiyan were going on. Now, Malads, kindly turn to page 89 of the paper book.
Just wait, Mr. Sibal, server is down actually.
Oh, I see. Is that all right now, Malads? Is the server functioning?
Not at all.
May I read it, Malads? Slowly.
Just wait, Mr. Sibal. Not. Mr. Kaushik, you have played some role to getting the server down. You have played some role to getting the server down.
Without your lordship's permission, I can't do anything. Let's
UPSC can do.
never.
चेक करो क्या पोजीशन है. फाइल फिजिकल फाइल. Yes, which page you are referring, Mr. Sibal?
Page 89, Malads, page 89.
We are taking the help of physical file.
All right, I appreciate that.
Page 80.
89. This is, Malad, these FAQs were at a time when the Janhit Abhiyan matter was going on in court. And kindly look at page 89, question number 12.
Yes, please.
Question is, if a person belongs to other backward classes in a state list, but not in the central list, can he apply for income asset certificate? And the answer is, Malads, para 2 of annexure so and so of OM so and so regarding income and asset reads as under. Therefore, if a person belongs to OBC in a state list, but not in a central list, she can apply for income and asset certificate for applying to posts and services in the government of India to avail of EWS reservation subject to fulfilling other conditions as mentioned in said OM dated 31/1/2019. Right, Malad? Now kindly come to page 283 of the paper book. This is the order of the Supreme Court.
283.
OBC.
That is 283.
283. Whereas now you will see how the central list of OBCs came into being. I'm giving you the genesis of that. Now kindly come to this judgment. This is 1995 3 SCC Supreme Court 146. And just kindly come to page 283, paragraph 4.
Just wait. Achha. 283 years.
Now, kindly see paragraph 4. This is part of the judgment.
Para number 4.
Para 4. In the present case, the Respondent Union of India has filed an affidavit in which it is pointed out that the number of candidates belonging to OBC who have qualified to appear for the preliminary examination is 10 times the number of posts. If in the circumstances, the government, if in the circumstances, government has not thought it necessary to relax the upper age limit for the OBCs, it cannot be said that the government has not applied its mind.
Date.
The date is November 21, 1994. Just note the date of this order. November 1, 1994. The government says, we have applied our mind, but the number of people appearing in the OBC are much more than the number of vacancies available. Therefore, we are not giving them this benefit. Now just come to 284 and note the date there. The next page, 25th January 1995. Just 2 months thereafter. What does the government of India do? The undersigned is directed to refer to paragraph 4 of this department's OM, dated 22/10/93, and to say that representations were received for the grant of age relaxation to other backward classes to enable them to compete for the vacancies reserved for them. The issue was considered and it was decided that the upper age limit prescribed for direct recruitment shall be relaxed by 3 years in respect of candidates belonging to other backward classes. So, the central government's OBC list, when they appear for these examinations, is granted 3 years age relaxation. That's the policy of the government of India. Right, Malas? Now, the UPSC thereafter gives them 3 extra chances. Page 106. Apart from age relaxation, then the UPSC at page 106 gives them 3 extra chances. Your lordships will find that at 106.
Yes, 106.
10. Your lordship has that table? Number of attempts, SC/ST unlimited, OBC 9.
Yes.
Right, Malad? So the OBCs in the central list, OBC in the central list have got an age relaxation of 3 years, and they have got an extension of attempting from 6 to 9, unlike EWS.
Right.
Right? Now, what is our case before your lordships is simple. We are OBCs in the state list. If the central OBCs are entitled to 3 age relaxation and 3 extra attempts, why not the state list?
Yes.
Nobody disputes that we are OBCs. Nobody disputes that fact. They say these OBCs are different from the OBCs in the central list. What difference does that make? I belong to the same class. What's the intelligible difference here? You give your central OBCs 9 chances and you give them age relaxation. You say, I'm not going to give these people age relaxation. In other words, an OBC in the state list will get only 6 chances. He will not get age relaxation. OB in the central list gets 9 chances and he got age relaxation. I mean, this is shocking, Malas. There is no rationale for this. And they keep on saying the lists are different. Of course, the lists are different because that's constitutionally accepted. That the state is entitled to have a separate list of OBCs under the 105th Constitutional Amendment, upheld pursuant to a judgment of the court. And Malas, kindly see the number of OBCs. 671 OBCs, Malas, in the state list. 1070, Malas. Page 1070. 1/5 of all OBCs in India. Well, page 1070, let's kindly have a look. Your Lordship has 1070?
Yes, sir. Yes, sir. Yes, please. And accept P31.
Yes, and see, Maharaj A, item A there at 1070. If the state list is abolished, nearly 670 OBC communities which are there in the state list would have lost access to reservation in educational institutions and in appointments. This would have adversely impacted nearly 1/5 the total OBC communities. So how can a government of India benefit one set of OBCs and give them age relaxation and give them 9 chances, and Maharaj discriminate another set of OBCs and say we'll not.
Where is this now?
7, kindly see page 1072. Point 8 and 9, Maharaj.
Mark it. This one, this one.
1072, items 8 and 9, Maharaj.
Yes, please read.
While the socio-economic condition of the general category was much ahead of the SC, STs and better than OBCs, it was noted that there might be segments within the GC, general category, having status equal to or worse than the average OBC in several parameters, such as education, occupation, land holding, health and housing. People from such segments with multiple deprivations were likely to form the economically backward classes or poor within general category as a class. The important finding was that at the lower end of the respective spectrums, the general category in OBCs were comparable on the weakness on a large number of parameters. The weak status on literacy and primary education, land holding, housing was not too different at the lower end of the two social groups. This was the reason, Manoj, why EWS category was created. Now, we are not concerned with the EWS at the moment. Our point is very simple. You cannot deprive us of the benefit that you yourself give to the OBCs in the central list. And there is no rational basis for denying that to us. And it's, as I told your Lordship, it's 1/5 of the total number of OBCs in the country. This is great injustice, Malas. That's the only argument I have. I can't have any other argument. And then what is their argument in reply? These OBCs are different because they are not the same as the central list. Of course, they are not the same as the central list. That's recognized by the Supreme Court itself. That's why a separate list was accepted and said that under the 155th Constitutional Amendment we were allowed. So that's one argument. Then this specious argument that it will take a number of weeks. This is the only attempt was not to honor your Lordship's order. Because if this was the problem, on the 15th, your Lordships passed the order on the 14th. On the 15th, they could have filed an application before your Lordships that this is going to take time. They waited till the portal was closed on 21st, and then they filed the application. And Maharaj, may I just tell your Lordships, Maharaj, originally, UPSC was a party to this petition in 2024. This petition is not filed in 25. It is filed in 2024. They chose not to, they filed an application. UPSC is not a necessary party. So please delete us. The moment your Lordships passed an order, they came with an application saying, no, don't do this. And DoPT for 1 year never filed a reply, and tonight they are filing a reply. And giving these reasons to your Lordships. Why would they wait, Maharaj, for 1 year to do this? Because they don't want to give the benefit to the OBCs. Well, this is very unfortunate. Anything else?
Data itself says EWS applicants must have male and lesser.
We are not concerned with that. Then, Maharaj, the other argument, the third argument is, if your Lordships will remember, in that judgment of the court, they said that the number of applicants is much greater than the vacancies, right? And despite that, within 2 months, Maharaj, they granted OBCs that benefit. They are saying the same thing here.
Yes.
They are saying the same thing here. So, Maharaj, if that was the reason, why did they issue the circular and give the benefit? Now, kindly see here, Maharaj, at page 13 of our written submissions, Maharaj. Page 13 of our written submissions. Your Lordship has that?
Yes, please.
Now, if your Lordship looks at the table, you will see that as far as SCs are concerned, my lords, our number of candidates is 1022 and recommended for appointment is 106. Just come to OBCs, number of candidates 673 and the number of recommended for appointment is 215. That's the case. That is true of every case. So what's so special about the reason that they are giving now? That was the case then. When the Supreme Court said that, that's the case now. And yet within 2 months, they gave that benefit to OBCs. They don't want to give the benefit to us. 7 years. Since then, Malaj, 7 years have passed. And this is, Malaj, you cannot, when you talk about equality, when you want equality of opportunity, when you want the upward movement of the backward community, Malaj, then you with high sounding words, you tell the world that this is what you want, and on the ground you discriminate. And one set of people you help, the other set of people you say you won't give. Well, that's all that I have to say. I'm deeply obliged to you.
Who else? Mr. Consul, through DC, you are appearing for whom?
My lords, I'm representing Union of India, my lords.
Yes, please.
Respond number 1 and 2. There are a number of petitions. If any other petitioner also wanted to speak, then otherwise start, my lords. May I start, my lords?
Yes, please.
Lordships. My lords, my learned friend, Mr. Sibal, has made an argument. But before that, if your lordship will kindly have pleasure to see the relief which has been prayed by the petitioner at page 62 of the writ petition, my lords. Kindly have pleasure to see that. What he has been asking in the writ petition and what he is making here and what he is asking here in his argument. So I invite my lords to page 62. Kindly see, my lords. The lordship would get it, my lord?
Yes, yes, please.
Lordships. My lords, the relief is at page 62. My lords, 7, serial 7, that is A. Pass an appropriate writ in the nature of certiorari, striking down the DoPT OM dated 31/1/19, annexure P1, and FAQ dated 19/9/2022, annexure P2, issued by respondent number 2, DoPT, to the extent it accords parity to candidates of EWS category with the candidates of general category in age criterion and denies candidates belonging to EWS category any age relaxations as has been extended to SC, ST and OBC. So, my lord, the relief is sought to be claimed on behalf of EWS candidates, not for OBC, which my learned friend is trying to canvass, my lord. I will explain that, my lord. My friend is smiling. I will explain that. Then, my lords, it's further strike down CSE 24 notification issued by UPSC to the extent it does not provide any age relaxation for the EWS category. And then B is to pass appropriate writ order or direction in the nature of mandamus to the respondents, directing them to extend the same relaxation concession in age attempt as is extended to candidates belonging to central OBC list. Also to the candidates belonging to EWS category in direct recruitment in employment under the central government. So here also, they are claiming the same thing, my lords, and they want a mandamus to be issued to the government to make a policy or to legislate, my lord, for granting this benefit to EWS, which till now the government has not taken a policy decision. Now, my lord, in order to just respond to the argument of my learned friend, where he was showing the judgment of this honorable court, of the Honorable Supreme Court, dated 21/11/94 in K. Uday Kumar's case, my lord, that after 2 months of that judgment, the government of India took a policy decision and granted it. So, my lord, at least my learned friend is admitting this fact, that it is not by virtue of any direction of the court, but it is a decision taken by the government of India that certain benefits were, rather certain concessions were extended to OBC category persons. Now, my lords, before coming into the merit and responding to my learned friend's argument, I want to place certain things in my own way, my lords. Now, my lords, kindly come to my counter affidavit, my lords. Now, Lordship have got my counter affidavit, my lords?
Yes.
Lordships. Now, my lords, I have shown, my lords, the prayer portion made by my learned friend's client. Prayer. Now, my lord, if your lordship will see the counter affidavit, they have short quashing of, my lord, annexure P1, P2, and P3, my lords. And annexure P3 is, my lords, Lord, if your lordship will see the counter affidavit, the same, my lord, of which they have shot the quashing, that is, my lord, that is at page 68 of the writ petition, and the same document is at page 24 of my counter affidavit, my lord. That is the OM dated 31st January 2019, my lord. Now, my lord, in the entire OM, there is no provision of, except, my lord, grant of reservation, there is nothing. Now, my lords, he is seeking quashing. To the extent he says that the benefit of age relaxation and the benefit of attempt relaxation has not been mentioned here. Now, my lord, if there is no provision in this OM with respect to age relaxation or attempt relaxation, the only provision is, and the procedure has been laid down with respect to grant of reservation to the EWS candidates, my lord. And, my lord, if your lordship will see other two OMs, my lord, issued by Government of India, my lord, that your lordship will see from my counter affidavit, my lords. I will invite my lords' very kind attention to my counter affidavit, my lords. R1 at page 20. Lordship will have kind pleasure to see, my lords. Your lordship got it, my lords?
Yes, please.
Lordships. My lord, this is dated 17th January 2019, my lords. My lord, it clearly contemplates that.
No, but page 30 is the blank one.
Page, my lord, I am at page 20, my lords.
Page 20.
Lordships, R1.
Yes.
This is 17th January 2019, my lords. Lordships got it, my lord.
Yes, please.
Lordships. Now, this is the office memorandum, my lord, issued by Ministry of Social Justice and Empowerment, Department of Social Justice and Empowerment, my lord, dated 17th January 2019. Now, this talks about reservation for economically weaker sections in civil posts and services in the Government of India and admission in educational institutions. It says, my lord, in pursuance of clauses 15(6) and 16(6) in the Constitution, while the Constitution 103rd Amendment Act 2019, and in order to enable the economically weaker sections, EWS, who are not covered under the existing scheme of reservation for the scheduled caste, scheduled tribes, and the socially and economically backward classes to receive the benefit of reservation on preferential basis in civil post and services in the Government of India and admission in educational institutions. It has been decided by the government to provide 10% reservation to EWS in civil post and services in Government of India and admission in the educational institutions. So, my lord, plain and simple, it talks about grant of reservation to the EWS category of candidates, my lord. Now, my lords, if your lordship will kindly turn to next document at page 22, that is another OM dated 19th January 2019. May I, my lords?
Yes, please.
Lordships. 19th January. This has been, my lord, issued by Government of India, Ministry of Personnel, Public Grievance and Pensions, Department of Personnel and Training, my lords. That was Ministry of Social Justice and Empowerment. This is by the Ministry of DoPT, my lords. My lord, this whole exercise was done by the Ministry of Social Justice and instructions are issued by the DoPT, my lords. Now, if your lordship will see, reference is invited to Ministry of Social Justice and Empowerment OM dated 17/1/19. Now, my lord, it is reiterated again that 10% reservation to EWS in civil post and services in Government of India in admission in educational institutions. So for two purposes, my lord, one is for admission in education institutions and other is for reservation on civil post in Government of India, my lords. Now, my lord, this is for Government of India only, my lords. Lordship will consider. Now, my lord, thereafter, my lord, their lordships have the Government of India has prescribed, my lord, how to, my lord, determine which person falls in EWS category, and for that purpose, the parameter has been mentioned at serial number 2, my lords, in this document. If your lordship will see that persons whose family owns and possess any of the following assets shall be excluded from being identified as EWS irrespective of the family income. My lord, that has been prescribed here. Now, my lords, after these two OMs, the third OM is 31st January 2019, my lords, which the petitioner have challenged. And I have shown to my lords that this is the OM issued by Ministry of DoPT for laying down the entire procedure how to avail the 10% reservation by EWS category candidates. And that is only with respect to reservation in post, reservation in admission in educational institutions. It has got absolutely nothing to do with, my lord, age relaxation or attempt relaxations. Now, my lords, if the petitioner has sought quashing of this, now even for the sake of argument, if I accept the argument if it is quashed, then the entire benefit of reservation to the candidates of EWS will go away, my lord. They can't get, because only by virtue of this, wherein the procedure has been let down, they are getting the reservation. Now, my lords, I will explain that, but age and attempt is not covered by 16(4), my lord, of the Constitution. It is covered by 16(1). That I will explain later on, my lords. And here, what has been conferred is reservation under Article 16(4) of the Constitution of India, my lords. Now, my lords, for a moment here, I will invite my lords' kind attention to the articles. My lords have occasion to see the articles on number of occasions, but then I will invite my lords' attention to kindly read it, my lord, with me, my lords. Your lordship has got the book, my lord. Constitution.
Constitution. Upload. रेफरेंस पे अपलोड नहीं है
Lord, your lordship have got it, my lord?
Yes, we got it.
Lordships. Lord, I will place, my lord, two provisions of Article 15 and then 16, my lords. My lord, Article 15, Clause 5, my lords. Now, my lord, Clause 5, rather, my lord, Clause 1, first, your lordship will permit me to place. Article 15 says prohibition of discrimination on the ground of religion, race, caste, sex, or place of birth. The state shall not discriminate against any citizen or on any grounds only of religion, race, caste, sex, place of birth, or any of them. And, my lord, the exception to that has been carved out, my lord, in 5, my lords. Now, that says nothing in this article or in subclause G of clause 1 of Article 19 shall prevent the state from making any special provision by law for the advancement of any socially and educationally backward class of citizens. Lord, my stress is on class of citizens, or of the scheduled castes or scheduled tribes, insofar as such a special provision relate to their admission to educational institutions, including private educational institutions, whether aided or unaided by the state, other than minority educational institutions referred to in clause 1 of Article 30. And then 6, my lord. It's very important because it talks about the EWS. Nothing in this article or subclause G of clause 1 of Article 19 or clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any economically weaker sections of citizens. And thereafter, my lord, other than classes mentioned in clause 4 and 5. So, my lord, it recognizes the distinction that there are 2-3 separate classes: scheduled caste, one class; scheduled tribe, one class; OBC, another class; and economically weaker sections are 4th class, my lord. Then, my lords, any special provision for the advancement of any economically weaker sections of citizens other than the classes mentioned in clause 4 and 5, insofar as such provisions relate to their admission to educational institutions, including private educational institutions, whether aided or unaided by the state, other than minority, so and so, subject to maximum of 10%.
Manoj,
So
may I be
10% is
excused
the
for a
higher
while?
limit.
I'm sorry to interrupt. May I be excused for 5 minutes, Manoj? I've been called in another court. I'll be back, Manoj.
Yes, please.
Lordship. Which in the case of reservation would be, in addition to existing reservations and subject to a maximum of 10% of the total seats in each category. Now, my lord, explanation. For the purpose of this article and Article 16, economically weaker sections shall be such as may be notified by the state from time to time on the basis of family income and other indicators of economic disadvantage. So, my lord, it has been explained what is economically weaker section, my lords. Now, my lord, for that purpose, my lord, I have read this, and for another purpose, that distinct class has been recognized, that they are of distinct class and they are not same class. So there cannot be a parity between them, my lords. Even with respect to scheduled caste, scheduled tribes, OBC cannot have parity. Now, my lord, in Indira Swami's case, in Indira Swami, the Supreme Court held that so far as economically weaker sections are concerned, in absence of any provision in the constitution for them, because the only provision was socially and educationally backward. There was no provision for economically backward. So there cannot be any special provision. And therefore, my lord, that necessitated, my lord, when the policy decision was taken by the government to extend this benefit, then that necessitated 103rd Constitution Amendment, my lords. Now, my lords, kindly come to clause 16, Article 16. And, my lord, these two articles are enabling provision only, that the state can make either law or provision for extending the benefit of reservation to them, my lords. And it says the word may. That your lordship have seen just now, that nothing in this article shall prevent the state from making. So the language is such that there is no mandate. The state can do it. It may not do it. And explanation also, my lord, as may be notified by the state from time to time. Then, my lord, the most important, Article 16. My lord, Article 16 again talks about equality of opportunity in matters of public employment. There shall be equality of opportunity for all citizens in matter relating to employment or appointment to any office under the state. Now, my lord, this talks about recruitment or joining an office, that is employment. Now, my lords, if your lordship will straight away come to clause 4, my lords. Now, my lord, it says, nothing in this article shall prevent the state from making any provision for the reservation of appointment or post. So it talks about reservation only. Any provision for the reservation of appointment or post in favor of any backward class of citizens, which in the opinion of the state is not adequately represented in the services and the state. Now, my lord, I pause a moment here and say, my lord, that so far as the castes, my lord, or class other than scheduled caste, scheduled tribes, and other backward category citizens, it is a deeming provision that they are adequately represented in service. But, my lord, one segment has been carved out, that is economically weaker section of society. My lord, otherwise they are adequately represented, my lord, in service. So it's not a class. EWS is not a class like OBC, my lords. It's a completely distinct and different class and cannot be compared in any manner with either OBC, SC or SC. Then, my lords, kindly come to clause 6, my lord. That talks about, that has been inserted consequent of, my lord, in the 103rd constitutional amendment, my lords. It says, nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any economically weaker sections of citizens other than the classes mentioned in clause 4, in addition to the existing reservation and subject to a maximum of 10% of post in each category. Not completely a distinct provision has been inserted for this fourth class, that is economically weaker sections. Not, they are neither socially nor educationally backward. They cannot be treated to be socially and educationally backward class of persons, my lord. They are economically weaker sections, meaning thereby the affluent class among these people, they have been adequately represented in service, my lords. So only a small fraction of that, 10%, who are identified under this category can be extended the benefit of reservation and reservation only, my lords, till now. And that was the policy decision of the government. Thereafter, the bill was proposed, my lord, for Constitution Amendment 103. Amendment was passed by the Parliament, and thereafter, enabling provision was made. And based on the enabling provision in the Constitution, my lords, the Government of India took consensus decision to extend up to 10%, that is 10% reservation to the economically weaker sections of society, my lords. Now, your lordship have seen this aspect of the matter, that how the whole scheme has come into play, my lords. Now, my lords, here, before I come to the other parts, my lord, now, my lord, so far as the writ petition which has been filed by the petitioners, Now, my lord, they have no fundamental right to claim any relaxation or any concession from the government. It is only that the government, if makes any policy for granting any relaxation or concession, they can get it, my lords. Now, my lord, once such policy is made, in case there is any discrimination in that policy, definitely they can come to the court and claim any discrimination on that basis, my lord. Now, and that is only in the same class of persons, my lord, not a distinct class of persons, my lord. Now, in the present case, in the writ petition, the petitioners are seeking parity on the basis of what has been conferred to the scheduled caste, scheduled tribe, and OBC class of persons, my lord. Now, there cannot be any parity on that basis, my lord. Now, my lords, if your lordship will further see that, my lord, so far as this, now, my lords, same problem took place, my lord, when OBC were granted the benefit of reservation, and they also wanted relaxation in age and attempt as at par with the scheduled caste, scheduled tribe people. Now, my lord, a writ petition was filed, and my lord have seen the judgment. I will straight away invite my lords to that judgment of C. Uday Kumar, my lord. Now, if your lordship will see in our, my lord, we have enclosed in our counter affidavit also. Now, my lord, kindly come to, my lord, page 70. Sorry. 70 of our counter affidavit, my lords. If your lordship will come to page 70, the judgment is 1995 supplementary 3 SCC 146. My learned friend has also cited one paragraph, paragraph 4 of this judgment. I am citing the entire judgment, my lord. Now, my lords, if your lordship will permit me to place it, my lords. My lord, paragraph 2 of this judgment at page 71, my lords. The provisions of reservation in services under the state made in Article 16(4) of the Constitution is enabling. It is not obligatory on the government to keep a reserved post in its services. Now, to what extent within constitutional limits spelled out in what manner and in which of the services the reservation should be kept is a matter for the government to decide, taking into consideration all the relevant factors. The court cannot give direction to the government to keep reservation or the manner in which and the extent to which it should keep it. Clear-cut, my lord, indication was made with respect to OBC, my lords. Then, my lords, now very important paragraph, paragraph 3, my lords. The Constitution itself recognizes the distinction between the scheduled caste, scheduled tribes, and other backward classes in the matter of reservation. My lord, I am repeating. The Constitution itself recognizes the distinction between the scheduled caste, scheduled tribes, and other backward classes in the matter of reservation, merely because reservations are kept or concessions are given to scheduled caste, scheduled tribes, which are not extended to the OBC, the reservations and concessions do not become discriminatory. Now, my lords, in the present case, the respondent Union of India has filed an affidavit in which it has pointed out that number of candidates belonging to OBC who have qualified to appear for the preliminary examination is 10 times the number of posts. If in the circumstances the government has not thought it necessary to relax the upper age limit of the OBCs, it cannot be said that the government has not applied its mind. And it was writ, hence the petitions are dismissed. Same analogy, my lord, here they are also seeking, my lord, seeking a parity with the OBC, scheduled caste and scheduled tribe, which are distinct class among themselves, my lords. Now, my lord, thereafter, if your lordship will kindly turn to the next page, R4. My lord, after the Article 16(4) and 15(4) came into being, my lords, and the OMs were issued, writ petition was filed before the Honorable Delhi High Court, my lord. Again, seeking the same relief, my lord, challenging that they should also be given benefit of relaxation, my lords. Now, if your lordship will see, although it's a judgment of the Honorable Single Judge, but the analogy which has been drawn, my lord, is important. Now, my lords, kindly see from paragraph 5 onwards, my lord. By virtue of Article 15(6) of the Constitution, the states are empowered to make a special provision for the advancement of any economically weaker sections of citizens other than the classes mentioned in clause 4 and 5, and to make a special provision relating to their admission to educational institutions, including private educational institutions, whether aided or unaided, other than minority institutions. In addition to existing reservations subject to a maximum of 10% of the total seats in each category. Similarly, 16(1) empowers the state to make provision for reservation of appointment or post in favor of any economically weaker sections other than classes mentioned in clause 4, in addition to the so-and-so. Then, my lords, respondent number 1, your lordship will see, same thing, my lord, same OM. Wide office memorandum dated 31/1/19, which is under challenge in the present writ petition also, provided the persons belonging to economically weaker sections who are not covered under the scheme of reservation for SC, ST and OBC and 10% reservation in direct recruitment in civil post and service in the Government of India. Now, respondent number 2 issued a notice of examination on 19/2/19 bearing so and so for conducting civil service examination, wherein every candidate appearing was permitted a maximum of 6 attempts. However, certain relaxation with regard to maximum number of attempts for SC, ST, OBC category candidates were given. Respondent number 2 retained the same condition for conducting civil service examination 2022 wide notice number 5/2022 CSP dated 22/2/2022. The petitioner in the present petition is seeking relaxation primarily on parity, but had failed to challenge the notice dated 2/2/2022, admittedly wide the office memorandum dated 31/1/19 and notice dated so-and-so. Respondents have formed policy to provide certain relaxations to certain sections of society. The policy is framed by the state based on the circumstances of fact and law, a quantifiable data, including constraints based on its resources. Now, it is settled law. While exercising jurisdiction under Article 226 of the Constitution, the courts does not frame policies which primarily are left to the wisdom and domain of legislature/executive. The court does not sit in appeal to amend the policies. However, the same can be set aside on the ground of being unconstitutional. The court does not and cannot act as appellate authorities examining the correctness, suitability, and appropriateness of a policy. The scope of judicial review when examining a policy of the government is to check whether it violates fundamental rights of citizens or is opposed to the provisions of the Constitution or opposed to any statutory provision, etc. It cannot be interfered with policy either on the ground that it is erroneous or on the ground that a better, fairer, or wiser alternative is available. This is what my learned friends is seeking for. Now then, in Veer Singh versus Delhi Jal Board 2018-10 SCC, the apex court held Article 16(4) is an enabling provision. It enables the state to provide to backward classes, including scheduled caste and scheduled tribes, reservation in appointment to public services. Such reservation is to be provided on the basis of quantifiable data, indicating the adequacy or inadequacy, as the case may be, of the representation of such classes in government service. The data, which is the basis of satisfaction of the state being verifiable, is open to judicial scrutiny on limited ground of relevance of the circumstances on which the satisfaction is molded. The policy decision to provide reservation, of course, is beyond the pale of judicial review. Therefore, the policy decision taken qua relaxations on attempt on age limit and on payment of examination fees is beyond the scope of judicial review. More so, the legality of office memorandum dated 31/1/19 and notice dated 2/2/19 is not under challenge. The court cannot thus issue the mandamus for framing a policy. Then, my lord, the court has referred to an earlier judgment in State of Punjab versus Ram Lubhaya Bagga. The court held, now we revert to the last submission, whether the new state policy is justified in not reimbursing an employee his full medical expenses incurred on such treatment. If incurred in any hospital in India, not being a government hospital in Punjab, question is whether the new policy, which is restricted by the financial constraints of the state to the rates in AIMS, would be in violation to Article 21 of the Constitution of India. So far as questioning the validity of government policy is concerned, in our view, it is not normally within the domain of any court to weigh the pros and cons of the policy or to scrutinize it and test the degree of its beneficial and equitable disposition for the purpose of varying, modifying, or annulling it based on, however, sound and good reasoning, except where it is arbitrary or violative of any constitutional, statutory, or any other provision of law. When the government forms its policy, it is based on number of circumstances, on facts, law, including constraints based on its resources. It is also based on expert opinion. It would be dangerous if the court is asked to test the utility, beneficial effect of the policy or its appraisal based on facts set out on affidavits. The court would dissuade itself from entering into this realm, which belong to the executive. It is within this matrix that it is to be seen whether the new policy violates Article 21 when it restricts reimbursement on account of financial constraint. Then, my lord, the Directorate of Film Festival versus Gaurav Ashwin Jain, the court held 2007 4 SCC 737. The scope of judicial review of government policy is now well defined. Court do not and cannot act as appellate authorities examining the correctness, suitability, and appropriateness of a policy. Nor are courts advisors to the executive on matters of policy which the executive is entitled to formulate. Scope of judicial review when examining a policy of the government is to check whether it violates the fundamental rights of citizens or is opposed to the provisions of the Constitution or opposed to any statutory provision or manifestly arbitrary. Court cannot interfere with policy either on the ground that it is erroneous or on the ground that a better, fairer, or wiser alternative is available. Legality of the policy and not the wisdom or soundness of the policy is the subject of judicial review. Large number of judgments were quoted, my lord. Then, my lords, Federations of Railway Officers Association versus Union of India, Ugar Sugar Works, so and so are few cases in this context. In view of the above, finding no merit, this petition is dismissed pending application, if any, stands disposed of. So another judgment of Delhi High Court. And then, my lords, next page also, I will not read it, my lord. Second judgment of Honorable Delhi High Court, my lord, in WPC 69396 of 2022 on 21/4/2022. My lord, relying on this judgment in Hari Sindooria's case, my lords, your lordship will see here also only just prayer portion, my lord. The petitioner has preferred for direction being issued commanding respondent to accord the benefit of age relaxation to persons belonging to economically weaker section at par with those stipulations as provided in SC/ST candidates. So, my lord, they are seeking direction on the basis of parity from another class, my lord. Then, my lords, thereafter, my lord, the Honorable Delhi High Court referred to all those judgments and dismissed the petition, my lord. Now, my lord, identical question arose in Bombay High Court, my lord. Annexure R6. If your lordship will come to page 81, my lords. Now, here the division bench of Bombay High Court, my lord, considered the same issue, my lords. Now, kindly see, my lords. It starts from page 2, my lords. Sorry, my lord, page 82. Now, my lords, paragraph 2, my lords. By this petition under Article 226 of the Constitution of India, the petitioners are challenging the communication dated 31st January 2022, whereby petitioners have been informed that they cannot be considered for the post of civil judge, junior division, and judicial magistrate since on the date of advertisement they are overage. And further, they cannot seek relaxation of age on the ground that they belong to economically weaker section, EWS, and not backward class. No, my lord, here it was with respect to judicial judiciary examination, my lord. Other was civil services, it is of judiciary. Now, straight away, my lords, the post was of civil judge, my lords. Now, my lord, straight away I invite my lord's attention to para 18, my lords. My lords, if your lordship will kindly come to page 93, my lords. It starts from para 18, starts from page 92. But, my lord, I will invite my lords to page 93 after third line, my lord. My lord, your lordship got it, my lord?
Yes, please.
Lordships. My lord, on a conjoint reading of Article 15, 4 and 6, two things emerge. Economically weaker sections are different than socially and educationally backward classes. Article 15(6) would apply to those persons who are not covered by Article 15(4). The basis of notifying the economically weaker sections and socially and educationally backward classes are also different. Therefore, a clear-cut distinction is made in the Constitution between backward class and the people belonging to economically weaker sections. Then, my lords, paragraph 19. Article 16(4) provides that nothing in the said article shall prevent the state from making. Now, my lord, kindly come to after 4, my lord, 3 lines from the bottom. The force, because that was a quotation, my lord, up till then. The aforesaid 2 clauses of Article 16 also brings out a distinction between economically weaker sections and backward class of citizens. Both these concepts, namely backward class and economically weaker sections, are not one and the same, but they are different, and the same is recognized by the Constitution also as different. Now, my lords, the Constitution 124th Amendment Bill, amending Article 15 and 16, also in the statement of object and reason state that because benefit of Article 15 and 16 is unavailable to economically weaker section, an amendment is brought in to give effect, to give benefit to economically weaker section. This also fortifies that economically weaker sections and backward classes are treated separately by the Constitution. Therefore, in our view, candidates belonging to economically weaker section cannot be construed as candidate belonging to backward class. Then, my lords, kindly see paragraph 22 in Rule 5C of the Maharashtra Judicial Service Rules of 2008. Now, the petitioner was seeking age relaxation. Here, my lord, if your lordship will see 5(3)(c), age, as on date of publication of advertisement, not less than 21 years and not more than 35 years, so and so. My lord, kindly come to the next page. My lord, next page, page 95. Rule 5(3) provides for age relaxation in respect of candidates belonging to communities recognized as backward by the government for the purpose of recruitment. Backward. As analyzed by us above, the constitutional framework brings out a distinction between the candidates belonging to communities recognized as backward and candidates belonging to economically weaker section. The age relaxation as per Maharashtra Judicial Service Rules is for those candidates who belong to communities recognized as backward and not in respect of candidates belonging to economically weaker section. Therefore, Rule 5(3)(c) of Maharashtra Judicial Service Rules as it stands today cannot be construed to mean that age relaxation provided by the proviso to Rule 5(3)(c) would be applicable to candidates belonging to economically weaker section. Therefore, in our view, the contention of the petitioners that since they belong to economically weaker section, the phrase backward used in proviso to Rule 5(3)(c) would include candidates belonging to economically weaker sections is required to be rejected. And then, my lords, kindly come to para 29. Now, my lord, in para 29, your lordship will find, may I, my lords?
Yes, please.
it is important to note that proviso to Rule 53C of the 2008 rules grant age relaxation to the candidates belonging to communities recognized as backward by government. The phrase backward in the proviso has to be read in the context of community, which precedes the said word and not in isolation. It is the candidate belonging to backward community who can seek the benefit of age relaxation under proviso to Rule 53C of 2008 rules. Insofar as the present petitioners are concerned, their claim is based on economically weaker section, which in our view would not constitute backward community. Therefore, on this count also, the contention of the petitioners to construe backward used as in Rule 5.3 to mean economically weaker section would not be correct reading of the proviso. Then, my lord, kindly come to para 33, my lords. To conclude, in our view, for the reasons stated above, the petitioners are not justified in seeking appointment for the post of CJ, JD and JMFC on account of they being overage as per 2008 rules. Rule is discharged, the petition is dismissed. Now, my lords, on the face of these judgments, there was no scope of granting interim order, but since on the first day, these could not be placed from the council appearing on our behalf or even by the petitioner, my lord. They were knowing fully well that there are these judgments of Delhi High Court, Bombay High Court, and even the Honorable Supreme Court. Since it was not placed, therefore, your lordship was persuaded to, my lord, grant extension of dates, my lord. This was to, my lord, disturb the whole schedule of civil service examinations, my lord. And, my lord, this interim order was based on an earlier order, my lords. Earlier interim order which was passed not with respect to civil service examination, my lord, with respect to the local state examination, my lord. That is dated 10/2/2025, my lords, wherein, my lord, this court was persuaded to consider the advertisement for recruitment in the state of Madhya Pradesh only. And there, my lords, if your lordship will see, in that case, it was Madhya Pradesh Employees Selection Board, Bhopal. That was under consideration, in which, my lord, the interim order was granted. My lord, I will not bother your lordship on this, my lord. Now, straight away, my lords. Then I come to, my lords. And therefore, there was no occasion, my lord, for them to get any interim order, my lords. Now, your lordship will consider another most important aspect of the matter, my lords, that has also been dealt with in these judgments, but I will separately deal with those aspects, my lord. Now, my lord, one aspect is that the petitioner went to Supreme Court, my lords, by filing an application under Article 2, my lord, 32 of the Constitution. Now, my lord, that has been mentioned by the petitioner in paragraph 4 of their writ petition subject matter brief, my lord, wherein they said that the petitioners approached the Honorable Supreme Court of India, my lord, that is in their writ petition, my lords. Petitioners approached the Honorable Supreme Court of India while writ petition civil number 303 of 2024. The Honorable Supreme Court in its order dated 14/5/24 in the writ petition civil number 303 dismissed it as withdrawn and accorded liberty to the petitioner to approach the High Court. Now, my lords, it is they who sought liberty to come to the High Court, my lord. Now, my lord, knowing fully well that they could not have come to the High Court, for such relief, they ought to have gone to the Central Administrative Tribunal, my lords, and not before this Honorable Court. There is no virus under challenge, my lord, of any act constituting the Central Administrative Tribunal under the provisions of the Administrative Tribunal Act, my lord. Therefore, my lord, in my counter affidavit, I have taken a preliminary objection that before approaching to this Honorable Court, my lord, the petitioner ought to have gone to the Central Administrative Tribunal, my lords. Now, my lords, in my counter affidavit, my lords, I have specifically stated in paragraph 6, my lords, at page 4, my lords. Your lordship will see paragraph 6 at page 4. It is pertinent to note that the petitioner has a statutory remedy to approach. My lord, admittedly, this is not a fundamental right, my lord. The Supreme Court refused to recognize it and did not entertain it, my lord. Now, my lords, therefore, at best, they could have stated to be infraction of any constitutional right or statutory right, my lords. Now, my lords, it is pertinent to note that petitioner has a statutory remedy to approach the Central Administrative Tribunal, since Section 14 of the Administrative Tribunal Act provides that Central Administrative Tribunal shall exercise jurisdiction, power and authority in relation to matters concerning the recruitment and service of members of All India Service. Now, my lord, they are talking about All India Service, my lord. Their claim is about filing of their application form in the Civil Service Examination, my lord. It is not here. It is submitted that Constitution Bench of the Honorable Supreme Court in L. Chandra Kumar versus Union of India, 1997, 3 SCC, has held that Central Administrative Tribunal will act as the only court of first instance in respect of areas of law for which it has been constituted, and it will not be open for the litigant to directly approach the High Court, even in cases where they question the vires of statutory legislations, except the legislation which creates the tribunal by overlooking the jurisdiction of the tribunal concerned. Thus, on this ground itself, the present petition is fit to be rejected. This is my objection, my lord, on the jurisdiction, that they have the Act itself has prescribed that first they have to go to the tribunal, my lords, in any matter relating to service. Now, my lord, if your lordship will permit me to place, Lord, Section 14 of the Administrative Tribunal Act, my lord, it talks about jurisdiction, powers and authority of the Central Administrative Tribunal. My lords, may I place it, my lords?
Yes, please.
Lordships. It says, save as otherwise expressly provided in this Act, the Central Administrative Tribunal shall exercise on and from the appointed day all the jurisdiction, powers and authority exercisable immediately before that day by all courts except the Supreme Court. In relation to, now what is in relation to, my lords? It is a recruitment and matters concerning recruitment. Now, my lord, this is a matter concerning recruitment. It is about recruitment by the UPSC, the civil service, through civil service examination on the civil post. Then, my lords, to any All India service or any civil service of the Union or civil post under the Union, or to a post connected with defense or in defense service, being in either case a post filled by a civilian. Then all service matters concerning a member of All India Service or. I stop here, my lord. Therefore, my lord, this writ petition on this ground alone is fit to be rejected and the petitioner be relegated to the Central Administrative Tribunal to raise their grievance, my lord. And L. Chandra Kumar, my lord, knows that it is a 7-judge bench, my lord, which has clearly laid down that they have to approach the tribunal which is constituted under the statute, my lord. Now, my lords, I have already dealt with the cases, my lord, so far as this matter is concerned, my lord, directly. That is the grant of, my lord, relaxation in age and attempt, my lord. Now, my lords, if your lordship will come, my lord, so far as this relaxation is concerned, my lord, the source of the relaxation is under civil services rules, my lord, 2024 and 2025, my lords. And they have not challenged that, my lord. The rules are not under challenge. My lord, the OM, which is under challenge, that is 31st January OM, does not talk about any relaxation. It only talks about grant of reservation, my lords. And it is only the civil services rules, my lord. Now, if your lordship will kindly come to the rules, my lord. That is, my lord, R2 in our counter affidavit at page 42, my lords. Now, my lords, I have shown my lords the office memorandums, my lord, 3 office memorandums. There, my lord, nothing has been talked about that, my lord. And it is only in these rules, my lord, R2 and R3, my lord, rather, so far the present petition is concerned, it talks about the examination of 2025, my lords. Now, if your lordship will kindly see page 57, my lords, of the writ petition. Of the counter, my lord, I'm sorry. R2 is it's a rule framed by the DoPT, my lord. If your lordship will see, it starts from page 43, that is, my lord, 2024 rules. And this is at page 57, my lord, 2025 rules, my lord. And my lord, these rules are not under challenge, my lord. Now, if your lordship will kindly come to page 59, my lord. Now, my lord, so far the rules are concerned, the attempt has been provided here, my lords. Now, page 59 says first, serial number 3, my lords, number of attempts. Every candidate appearing at the examination who is otherwise eligible shall be permitted 6 attempts at the CSE. However, relaxation in number of attempts will be available to scheduled caste, scheduled tribes, OBC, and PWBD category candidates. PWBD is benchmark disabled candidates who are otherwise eligible. The number of attempts available to such candidates as per relaxation is as under. Now, your lordship will see number of attempts, then category in which the candidate belongs. Scheduled caste, scheduled tribe, unlimited. Other backward classes, 9. Then PWBD. PWBD is, my lord, persons with benchmark disability. They have also got 9, my lord. This is the, my lord, breakup of the attempts, my lord. Then your lordship will kindly come down. Serial number 5 talks about the age in these rules, my lord. Serial number 5 says a candidate must have attained 21 years and must not have attained the age of 32 years on the 1st of August 2025. The candidate must have been born not earlier than 2nd August and not later than 1st August 2004. Now, my lords, 2. My lord, here is the relaxation. The upper age limit prescribed above will be relaxable. A, up to maximum of 5 years if the candidate belongs to a scheduled caste or scheduled tribe. So, my lord, 5-year age relaxation has been extended as a matter of policy to the candidates belonging to scheduled caste, scheduled tribes. Then, my lord,
5 years, 3 years, 3 years, that is there.
Your lordships. Now, one important thing I want to highlight, my lord, here is that it is not only limited to candidates of scheduled caste, scheduled tribe, OBC, or disabled, but there are other class of persons also whom these relaxations have been given so that they also can get the opportunity. Now, my lord, they are, if your lordship will kindly come to, my lord, kindly come to C, my lord, clause C. Up to maximum of 3 years in the case of defense service personnel disabled in operation during hostilities with any foreign country or in disturbed area and released as a consequence thereof. This is 1. Then up to maximum of 5 years in the case of ex-serviceman, including commissioned officers and emergency commissioned officers, short service commissioned officers who have rendered at least.
That is also there, just be in brief. You are reading each and every line.
Lordships, I will not read, my lord. No, my lord, I just wanted to highlight, my lord, that this is not dependent upon grant of reservation.
Yes.
This relaxation and concessions are completely and a distinct extension as a matter of policy by the government, and none of them can claim it as a matter of fundamental right or statutory right. And none of them has challenged it, my lord.
This you have already argued.
Lordships.
I hope
Now,
you
my
have
lords,
concluded.
I'm just, my lord, I will take some more time, my lords, then I will conclude, my lord. Now, your lordship will see that so far as my lords have seen the judgments. Now, my lord, I want to show, my lord, one of the celebrated judgment in the case of N. Thomas. My lord, that is also. My lord, a copy my learned friend will pass on to your lordships, my lord. There are certain paragraphs which are important for consideration of my lords, my lord. Kindly come to that. My lord, I will not read the entire judgment, my lord. My lord, this is the state of Kerala and another versus N. Thomas and others. It is 1976 2 SCC 310. Lord, I hope my learned friend has passed on the judgment, copy of the judgment to your lordships, my lord. Lordship have got it, my lord?
These all are uploaded. Only you tell us the relevant. Anand Thomas.
Your lord, your lordships, kindly straight I take your lordships to para 185, my lords. 184, 185.
Which para, please?
185, my lords.
Anand Thomas case.
Lordships, N. Thomas case.
So there is no 105.
185, my lords. Para 185.
Page number or para number?
Oh, I'm sorry. My lord, I am referring to para number, my lord, page, my lord, 385 at the top.
385 is also not there.
My lord, para 186, your lordship could get it, my lord.
ये आधे दो दे दिए क्या?
Actually, this is reported in SCC, my lords. So SCC citation.
ये लगाई नहीं पिन ने पिटकी पिटकी से मार दी. So 185.
Yes, my lord, 185.
Yes, please.
Lord, it says, my lord, in the first place, if we read Article 16.4 as an exception to Article 16.1, then the inescapable conclusion would be that Article 16.1 does not permit any classification at all, because an express provision has been made for this in clause 16.4. This is, however, contrary to the basic concept of equality contained in Article 14, which implicitly permits classification in any form provided certain conditions are fulfilled. Furthermore, if no classification can be made under Article 16.1 except reservation contained in clause 4, then the mandate contained in Article 335 would be defeated.
Yes.
Then, my lord, para 186. I have already observed that the fundamental guarantees provided by the Constitution have to be read in harmony with directive principles contained in Part 4. Again, if Article 16.4 is deemed to be the only mode of classification, then it would follow that Constitution permits only one form of classification, namely reservation, and no other form, so far as the services are concerned. This will render the concept of equality nugatory and defeat the very purpose which is sought to be achieved by Article 16.1. Equality of opportunity to all citizens does not mean equality to some and equality to others. As I have already pointed out, that in our country, there are large number of backward classes of citizens who have been granted certain concession and facilities in order to be able to compete with others. Does it mean that such citizens should be denied these facilities which may not fall under the term reservation. Milord, the word used was different relaxation, Milords. So this does not come under Article 16(4), Milords. Now, Milords, if your Lordship will read, I'll read further. Let us take few instances. A notification provides that all candidates for a particular post must apply before a specified date. A person belonging to a backward class of citizens living in very remote area gets information late. The government, however, in case of such backward class candidate, make a relaxation and extend the date. Can it be said that this has been resulted in violation of 16(1) because it does not fall within the reservation contemplated by clause 4 of Article 16?
Yeah.
It is obvious that intention of the government is merely to help the backward class of citizens to apply for the job along with others by condoning the delay for special reasons. Another instance may be where the state makes a relaxation regarding the age. Now, Milord, this is important. Another instance may be where the state make a relaxation regarding the age in case of backward class of citizens in view of the far-fetched and distant area to which the class belongs. Lastly, let us take the instance of the present case. The clerk belonged to scheduled caste and tribe were given a further extension of time to pass the test because of their backwardness.
Yes.
They were not exempted from passing the test. This could only be done under Article 16(1) and not under clause 4 of Article 16. Well, this is what I wanted to mention and persuade your lordships that these two, Milord, relief which my learned friend wants to seek a mandamus from this honorable court, now, Milord, cannot be granted because this is only up to the state to grant any extension or relaxation under 16(1) because such cannot be granted under 16(4) because it doesn't form part of 16(4). Now, Milord, lastly, Milord, there are other judgments also, Milords. Milord, I will
There are, yes, so you just give the.
admit that, but I will not read those judgments. But
yes,
my learned friend was trying to.
Yes, sir.
My learned friend was trying to put an analogy of OBC.
Yes, please.
My learned friend tried to make his submission, which is not at all in his writ petition, my lords.
Yes.
Now, they were trying that OBC of the state and OBC of the government of India. Now, my lord, the claim and the relief is for relaxation only for EWS category of candidates.
Right. Mr. Kaushik, you will also address.
Let's.
Therefore, that submission does not lead to.
Just a minute. Only for the limited purpose regarding.
Yes, Minister. To assist your lordships only as an officer of the court, Ministers, I have prepared written submissions in which Ministers, most of the aspects stated by the learned ASG have also been referred to. Yes. Only two aspects, Ministers, which seem to have not been adverted to is Ministers. The reliance on frequently asked question number 12 at page 89. Is in the context of FAQ 11. The FAQ 12 only clarifies that if you happen to be OBC, because under the constitutional scheme, if you are backward classes, then you are disentitled for the benefit of EWS. Whether an OBC of a state gets disentitled for the purpose of benefit of EWS. Question 12 only clarifies that because they are not central OBCs, therefore they will not be disentitled. The reliance relates to say that they are being recognized as OBC is completely misplaced. This is one relevant aspect. Another relevant aspect, the truth has come out of the submissions of Mr. Kapil Sibal. The intent of the petition in the prayers is something different. Now they say that we are state OBC and not central OBC, therefore it does not matter. We should be considered as central OBC. In that regard, my humble submission is, conferment of OBC status is governed by Constitutional Article 342. If they do not find any place in that presidential declaration and considered as central OBC, and my humble submission relates, they cannot equate themselves with the central ABC and transport themselves as central OBC for the purpose of getting the benefits, that too via the medium of invoking the jurisdiction of this honorable court. These two aspects may also be taken into consideration.
Malaj, may I now reply, Malaj?
Yes, please.
I'll just take about 10 minutes, Malaj. I won't trouble your lordships, Malaj. Just a few things. Number one, I have never argued that OBCs must be equated with SCs and STs. I have not ever made that argument before your lordships. It's not in the petition. I have not made that argument. That's point number one, because OBCs under the Constitution form a separate class altogether. That's number one. Number two, I have not challenged the Office Memorandum of 2019 in my submissions. I have made no submission in respect of the OM of 2019. Right? Number three, Malaj, what is my simple contention? That there is a policy decision of the government of India and that's reflected at page 284 of in the Office Memorandum, which was